Hi everyone. In this video, I would like to talk about the case of Mr. Vhong Navarro, a Filipino celebrity, whose criminal cases, one for rape and the other, for acts of lasciviousness, were dismissed by the Supreme Court recently. People are asking why it is so fast for the cases to be dismissed by the Supreme Court when these cases are still pending in the trial courts. It must be recalled that the criminal complaints against Vhong Navarro were previously thrown out by the Department of Justice for lack of probable cause. Probable cause is defined as the existence of such facts and circumstances as would excite the belief in a reasonable mind, acting on the facts within the knowledge of the prosecutor, that the person charged was guilty of the crime for which he or she was prosecuted. A finding of probable cause requires enough reason to believe that the imputed crime was committed by the accused. However, the complainant, through her counsel, filed a petition before the Court of Appeals, challenging the dismissal of the complaints. And in July 2022, the Court of Appeals ruled that the dismissal by the DOJ was wrong, and that the appropriate criminal informations for acts of lasciviousness and for rape, respectively, against Vhong Navarro, should be filed in the trial court. The Taguig City prosecutor complied with the order of the Court of Appeals and, after the informations were filed, the arrest warrant against Vhong Navarro was issued. He was placed under preventive imprisonment while his petition for bail was being heard. In December 2022, Vhong Navarro was granted temporary liberty upon posting a $1 million bail in his rape case. But both cases, for rape and for acts of lasciviousness, are now dismissed by the Supreme Court. Deciding on the appeal of Vhong Navarro from the decision of the Court of Appeals, the Supreme Court ruled that the Court of Appeals committed an error in finding that the DOJ committed grave abuse of discretion, amounting to lack or excess of jurisdiction, in dismissing the complaints against Navarro for lack of probable cause. The Supreme Court said that the determination of probable cause during preliminary investigation, for the purpose of filing an information in court, is a function that belongs to the public prosecutor, who directs and controls the prosecution of all criminal actions commenced by a complaint. It is executive in nature, the correctness of which is a matter that the courts ordinarily do not, and may not be compelled to, pass upon. By reason of the executive nature of this prosecutorial prerogative, courts cannot compel the prosecution of a person against whom the public prosecutor has found no sufficient evidence to establish probable cause for indictment. Courts cannot substitute their own judgment for that which is fundamentally in the domain of the executive branch. In the same vein, an accused may not be permitted to file a motion with the trial court for the quashal or dismissal of the indictment on the ground that the evidence upon which it is based is inadequate. Put simply, whether the evidence would rise or fall on its face is the sole prerogative of the public prosecutor to assess. Although the Supreme Court said that judicial intrusion is justified when the exercise of such authority is tainted with grave abuse of discretion amounting to lack or excess of jurisdiction, the Supreme Court ruled that the Department of Justice did not commit grave abuse of discretion when it dismissed the complaints against Vhong Navarro. In the instant case, the court finds that the prosecutor's findings of lack of probable cause against Navarro for the imputed crimes proceed from an adherence to the foregoing legal yardsticks, thus negating grave abuse of discretion on the part of the DOJ in denying Cornejo's petition for review. The prosecutor's findings appear to have been arrived at objectively. The prosecutor carefully, exhaustively, and deliberately evaluated the evidence on hand and the circumstances attending the case. The prosecutor had reasons to doubt the veracity of Cornejo's accusations, as the glaring and manifest inconsistencies pointed out in her complaints are readily discernible by common sense without need of rigorous examination or an expertise of a trial court judge for such purpose. To suggest that a prosecutor turn a blind eye to such glaring and manifest inconsistencies, under the premise that the evaluation thereof would already touch on the complainant's credibility to be solely assessed in a full-blown trial, would be to compel the prosecutor to satisfy himself or herself to mere allegations in a complaint, and abdicate his or her bounden duty to screen cases for trial, thus passing the buck to the trial courts. Citing Duterte v. Sandiganbayan, the Supreme Court pointed out the twofold purpose of a preliminary investigation: first, the paramount purpose to secure the innocent against hasty, malicious and oppressive prosecution and to protect him from an open and public accusation of a crime, from the trouble, expenses and anxiety of a public trial, and second, the practical purpose to protect the state from having to conduct useless and expensive trials. Thank you for watching. I will talk to you again soon. Stay safe.